Welcome to the Common Law lecture series, and in this particular uh, section, we will be looking at the law of contract. And obviously, the objective of this lesson is quite basic, and what we are looking at this morning is how a contract is formed, or in other words, what ingredients are necessary in order for you to have a valid contract. So, in order for you to maybe, let's say, cook a valid contract, what are the things which you must need to put in the mix? Let's make a start. Well, to begin with, we need four things. You might wish to call it the legal test, or the elements of a contract, or the various bits and bobs which is necessary in order for you to have a valid contract. The four things which you require: offer, acceptance, consideration, and an intention to form legal relationships. Now we will consider them one by one. The first thing to look at is, what is an offer? To put it very simply to you, I have got a pen in my hand and I wish to sell this pen to you for £5. And that is a clear, unequivocal offer to you. In this particular example, what I have in front of me, it's the story of Carlyle and Carbolic Smokeball Company. Now, the Smokeball Company was a company, as the name suggests, used to make some medicines which would stop influenza, particularly to those people who are using that particular medicine. One lady, Mrs. Carlyle, she bought the medicine because she read the instructions which the or the various representations which the companies made to the effect they said, look, you go and buy our medicine, and if you have influenza, we will give you £100 for it. So obviously, in good faith, the lady bought the medicine, and unfortunately, so it happened, she contracted influenza, and then she tried to sue the company. Well, obviously, the company now tried to backtrack themselves and says, hang on, that was not really an offer. That was really an invitation to treat. But the companies obviously couldn't get their way through, and in the court of law, the judge decided, look, there were two separate contracts, and in the section where you said you are willing to pay £100 to someone who uses your medicine, that constitutes clearly a contract, and that is an offer which you made to the outside world. And in this particular case, Mrs. Carlyle accepted your offer. So, just to sum up, offer is something which a person makes to the other. It has got to be clear, it has got to be unequivocal, in a sense that he is offering something of value to someone. And that is the first stage of the contract. And I have a little picture here. And obviously, in this case, someone is trying to sell the statue. And obviously, when the statue is being sold, arguably it is with the arms. So you're offering to sell the statue with your arms. So it has got to be clear, it has got to be unequivocal. Okay, moving on to the next stage of the contract, and that is known as acceptance. So if I offered to sell my fountain pen to you for £5, you have got three options. First option, to accept my offer of £5 and pay me £5 for it. The second option, you can make me a counter offer. Is it £5? Forget it. I'm not going to pay £5 for your pen. I'm only going to pay you £1 for it. So in other words, you make me a counter offer. And then it is really up to me whether to accept the offer or not. So that's the second option. The third option is, you might completely reject my offer and say, look, I'm not interested in buying your pen for £5. Thank you very much. So that's the third option. Obviously, the one which I'm really interested in is my first option, where I'm willing to offer you something of value, maybe a pen, and you accept my offer as it is without making me any other counter offer. In this particular example, we have hide and wrench. It's obviously a story of a person, or a case as you may like it, um, of someone who's trying to sell his farm to someone else. Now, in this particular example, it was Mr. Wrench who offered to sell his farm to Hyde for £1,000. Hyde, instead of accepting the offer unconditionally, rejected the price and offered to pay 950 as an alternative. Wrench obviously rejected this price. Hyde then tried to accept the original price and claim breach of contract when he realized that Wrench was selling it to someone else because he got a higher price. Obviously, in the court, Lord Langdale rejected Hyde's claim and held since the counteroffer amounted to a rejection of the actual offer, the original offer was no longer open for Hyde to accept. So, to put it in simple terms, if you're offering something up for sale, you must have another person who must accept the offer as it is. So that's the second stage. So we must have an offer and we must have an acceptance. Let us now move on to the third stage. A third stage is known as consideration. Now, to put it very simply to you, consideration is something which you pay to buy this particular promise. Now, let me go back to my previous example of me trying to sell you a pen. Once again, I have this lovely fountain pen. I wish to sell it to you and offer it to you for £5. And let us say you are an exquisite collector of fountain pens and you accept my offer of £5. I said, yes, I do accept your offer for £5. Now, you know pretty well that since this fountain pen is pretty much well in demand, I might go somewhere else and try and find if I can find a prospective buyer who might be willing to pay maybe £7 for it. So, in order for me to stop doing that, what you then do is, after you have accepted my offer, you might give me 50 pence or maybe a pound and say, look, I'm going to buy your pen. Here's a pound towards it. When I get the balance of my money in the next 2 days, I'll give it to you, and the pen is mine. So the 50 pence or the pound which you pay me, that is considered to be consideration. Or in other words, it is the price which you have paid to buy this particular promise. The promise of me trying to sell this pen to you. Now, all what the law says, consideration need not be adequate, but it must be sufficient. In other words, as long as you give me something of value, that would be classed as consideration. So, in other words, when I make an offer to you, you accept the offer, and then it's up to you to give me something of value, anything which you might consider is of value to me. And once you give that to me, you try and cement this particular promise. You stop me from going elsewhere and trying to sell what I'm trying to sell to someone else. All right. So that's the third stage of the contract. So you require an offer, you require an acceptance, and you also require a consideration for the offer. Now, moving on to the last stage, and that is known as an intention to form legal relationships. So, obviously, the two parties, when they're offering something up for sale, now there must be an intention to form legal relationships. Now, let's say, going back to my same example, me trying to sell you this pen for £5. Now, obviously, if the pen did not belong to me, but instead belonged to a good friend of mine, and it was her pen, and I was trying to sell it off to you, obviously, I can't be serious because there is no intention to form legal relationship because the pen obviously does not belong to me. So, in other words, I must be really serious about it, or there must be some element of seriousness in the whole business for this contract to stand. Now, let me give you this example of Balfour and Balfour. Now, in this example, what happened? The husband was going away abroad to work, leaving the wife behind. Now, the wife wasn't very well; she was a bit sick, and the husband told the wife, "Look, look, darling, when I'm away for this next couple of months, I will be paying you a certain sum of money whilst I am away. and when I come back, the money is all yours. I mean, this is what I'm paying for me being away for a certain period of time. And the wife accepted that in good faith. Now, a couple of months later down, the husband came back. Obviously, in the meantime, the husband didn't pay the wife anything as he had promised earlier on. So what the wife wasn't very happy about it, and the fact that the wife took the husband to court and said, "Look, this is what my husband had promised, and he didn't pay me for that." And the courts obviously held that, you know, there was no intention to form legal relationships, because in close family proximity itself, there's a presumption that there is no intention to form relationships unless it is expressly stated otherwise. Because if it were so, then the courts would constantly get flooded with cases of family members trying to sue each other. Another interesting example which comes to my mind is about a father and a son. Now, this particular son was no good, as some of the sons can really be. So the father, told the son, "Look, son, better pull up your socks. Try and do well in your exams, and if you do well in your exams, I'm going to get you a bike." Now, obviously, the son really liked that idea. Look, if I do well in my exams and if I do get a bike, that's a wonderful idea. So the son really did study and put a lot of effort in his exams, and eventually passed the exams. And then he said, look, dad, can I have my bike now as you'd promised?" The dad said, "Bike? What bike? You're supposed to be studying for your exams anyway. Forget about the bike. There's no question of any bike. And by the way, well done. You've done well in your exams." Well, obviously, that didn't really go very well with the son. And the son took the father to court and said, "Look, we have a contract. The contract said, I study, do well in my exams, my father gets me a bike." But unfortunately, the judge, sets aside the argument of the son and says, "Look, that in a family relationship, in close relationships, I'm afraid there can be no presumption of an intention to form legal relationships." Okay. All right. So just to do a gentle recap, so in order for you to have a valid contract, you must have four things: an offer, an acceptance, consideration, and an intention to form legal relationships. And once you have all these four ingredients, you've cooked up a contract exists. And if the other party now doesn't do what he or she has promised, then you can go up to court and say, "Oh, hang on, there is a breach of contract." Right. And finally, I'll leave you with one question for you to wonder upon, and that is, you know, why do courts feel that an agreement within a family setting should generally not be legally binding? Okay, have a little think about it, and maybe in the next lecture we'll be able to discuss it. Okay, thank you for listening.